So welcome to all of you to Banik's math class for OCS civil examinations. Last class we had a discussion on high courts. We had already started that. We had discussed the history of high courts, and as you are told that the first high court or the initiative was taken in 1961 under Indian High Court Act 1861. Sorry, and the first high courts were established in 1862 at Calcutta, Bombay, and Madras, respectively. And we have also noted that various high courts were set up in different times. Okay, different times by the Parliament under an act. So there have been high courts, and high court even the Parliament can establish high courts for union territories if it feels appropriate. So Article 214 states that there shall be high court for each states, but in the 7th Amendment Act, as you have noticed, as you can see on the screen, on the 7th Amendment Act 1956, there was a legislation passed to empowering the Parliament, to establish a common high court for two or more states. And accordingly, Parliament has the authority to establish. Okay, so that is Common High Court of India, Common High Court of a state. That means a Common High Court is a high court under which at least more than one state exists. So you can see that there are three Common High Courts at present. One is Guwahati High Court, Bombay High Court, and Punjab and Haryana High Court, or Chandigarh High Court, I can say. These are Common High Court because under them there are several states under this. For example, Assam under Guwahati High Court, Nagaland, Mizoram, and Arunachal Pradesh. So this implies that there can be more than one state under one high court, and there are benches at Kohima, there are benches at Aizawl and Itanagar. Also kindly go through the benches of high court different headquarters, because most of the high courts have their headquarters in capital, but some of the high courts have their capital headquarters in other cities, rather in cities other than capitals. For example, Madhya Pradesh has its capital headquarters. Madhya Pradesh High Court has its headquarters in Jabalpur, and then in case of Chhattisgarh, it is in Bilaspur, not in Raipur, and in case of Kerala, it is in Kochi, not in Thiruvananthapuram. So there are several high courts whose headquarters are located not in the state capital but in other cities in the state. So that also go through them and also find some benches of different high courts. For example, Bombay High Court has benches. Bombay, as you can see, Maharashtra, and your Goa, the two major states, and then Daman Diu and Dadra Nagar Haveli and DNH. Daman and Diu and DNH. They come under Bombay jurisdictions. Okay, and Chandigarh, you have the name mentioned Punjab, Haryana, and Chandigarh as a union territory also. So, Common High Court is the different type of courts that exist in several states, and the difference is that same procedure is maintained. President appointment, the things are done by the president. But only difference is between the single high court and common high court is that the salaries of the judges may be shared, The expenditures may be shared among the states from the state consolidated funds. That is also, it will be distributed. And as I told you, Parliament is authorized to establish High Court for union territories if it pertains up, if it feels appropriate, or if the situation, the number of population increases, then there may be a requirement for a high court in the union territory. So far, Delhi was the only high court union territories to have a high court, but after the creation of Jammu and Kashmir and Ladakh union territories. Now Ladakh, Jammu and Kashmir has got also a high court, and Ladakh comes under its jurisdiction. So it can be said a common high court, not in that sense, but it's a common high court because it has two union territories under its jurisdiction. Okay, so that is all about your the things about the setup of it. Then composition, strength. The strength of High Court is not uniform across the country because depending upon the size of the High Court or the population of the state, the strength is decided. So strength varies from court to court. That is, there are smallest jurisdiction or smallest strength is found in Sikkim having 3 judges, and there are more than 100 judges in Allahabad High Court. There are 27 approved judges for the Odisha High Court. Okay, so the strength of the High Court are decided by the President, whereas the strength of the Supreme Court is decided by the Parliament. But the jurisdiction of the High Court, the powers, jurisdictions, can be enlarged not only by Parliament but also by the state legislature too. Okay, this is called your strength. Strength is decided by the President. Then appointment. We have discussed the appointment procedure of Supreme Court judges. It is the same procedure followed here. The judges of High Court, the judges of High Court are appointed by the President in consultation with the CJI and two other senior most judges of the Supreme Court. So the collegium is 3. Apart from the consultation, the President also consults the governor of the state and the Chief Justice of the High Court. It takes their opinion, regarding this appointment. So apart from that, he also consults the governor of the state, governor or governors in case of common appointment, common high courts, and the Chief Justice of the High Court. But invariably we have to remember that the judges of high courts are appointed by President under Article 214. Okay, that is called the appointment of the judges. Now let us discuss the qualifications required to be a judge of High Court under Article 124. The qualifications of the judges are mentioned in the Constitution to be that he must be a citizen of India, he must have held judicial office under the government of India or state government for 10 years or more, or he must have, or he must have been an advocate of a high court or high courts for 10 years. So there are only three conditions. One is from that is a compulsory provision that citizen of India. Another, either of the two should be a compulsory provision. And if you compare between the qualifications of the required for the appointment of judges of High Court and that required for the appointment of the Supreme Court judges, you will find that there is no provision of appointment of eminent jurist as a judge of High Court recommended by the President. So the provision of appointment of eminent jurist as a judge in the High Court is not there. And also common lack that is common lack in the qualification of qualification for the judges of Supreme Court and High Court is that there is no basic minimum age qualification is required. So the qualifications and any change in the qualification can be made by the Parliament through an act. So that is called your qualifications. Oath and affirmation is administered by the governors of the state. Oaths and affirmation are administered by the governors of the state. They take the same oath. They will bear allegiance, faith and allegiance to the Constitution. They will serve people without ill will, bias, favor, and they will abide by the Constitution. So they are the protector of law. They are protector of the Constitution. Hence, they have more responsibility towards the Constitution. So there is a requirement. Okay, they take oath, and remember the oath is administered to them by the the things, and the oath take under Article 219. They take oath before the governor of the state concerned or any person nominated by him. Then you find the salaries of the High Court. The High Court you require, that is. They get a salary after the 7th pay amendment. Revision of salary was there. There was a revision in the salary, and their salary and others that is provided by the or decided by the Parliament. And at present, the Chief Justice of a High Court gets 2.5 lakh per month, and 2.25 lakh is assigned to a judges. It is after the 7th Pay Commission since 2018, this salary has been increased. And this salary is drawn from, or is a charged expenditure from the consolidated fund of the state or the states. So as I told you, in case of a common High Court, the partner states contribute the salary as determined by the President. However, the pension of the High Court judges are charged upon the consolidated fund of India. They do not get salary pension from the state, rather they get salary from pension from the union government. Hence, the pension of the High Court judges are a part of the union budget, and that charged expenditure upon the consolidated fund of India. Then you can consider if a resignation of the resignation, that is 217 under Article 217, they resign to the President. They can resign to the President in writing, by writing under his hand addressed to the President. So that is called your resignations. And the security of a tenure is there. Tenure is not fixed of the High Court judges. They don't have a particular period of time as tenure. They remain office until they retire at the age of 62, and this amendment has been enhanced. This age has been enhanced by 15th Amendment Act, 15th Constitutional Amendment Act 1961. So the retirement age of the High Court judges can be changed to a constitutional amendment enacted by the Parliament. Now at present, the retirement age or upper age limit of a judge is 62 years, stands at 62 years. Then removal. Removal of the judges is same as the removal of the judges of Supreme Court. They removed on the same ground, misbehavior and incapacity, and the same procedure is followed. We have already made a detailed discussion on the removal procedure, and I told you that removal procedure of the judges are borrowed from the American Constitution, and it is provided under Article 214 of the Constitution, 2144. They can be fired, they can be removed on the ground of misbehavior and incapacity, and a charge sheet will be prepared. Before that, 14 days notice, advance notice is served on the judge, and the charge sheet is to be allowed. Charge sheet is to be supported by 100 members in case of Lok Sabha and 50 members in case of Rajya Sabha. The motion, that charge sheet is accepted as a motion. It is if it is accepted, then it will be introduced in the house, and that will be accepted by the presiding officer. The presiding officer has also the authority to cancel or to reject the motion, and if he allows the motion, then the house in which the motion is introduced will constitute a 3-member committee. As I have already told you, the 3-member committee will consist of Chief Justice of India, any chosen Chief Justice of any High Court, and eminent jurist will be there. It will be a 3-member committee. They will look into the charges leveled against the judges, and if they find the report, if they find through the report that the judge is not guilty, then they will submit the report, and the resolution or the removal procedure will come to an end. But if the committee finds the judge guilty, then it will submit a report to the House, and on the basis of the report of the committee, the House will pass the resolution in special majority, and after it is passed in special majority, it will move to the second House. The second will again have to pass the resolution in special majority. After it is passed by special majority, then it will go to President, and after President releases an order, the judge will be declared to be removed. And if they are removed, they are not entitled to any kind of retirement benefits, and there will be severe consequences of the removal. So these are the removal procedure. We have just lightly discussed it, but we have taken a good note on that. And the removal of the judges is governed under Judges Inquiry Act 1968, enacted by Parliament. So removal of the judges is not a judicial action, rather it is an executive and legislative action. It is an executive and legislative action, but it is a difficult and cumbersome procedure to remove a judge, and hence no judge has so far been removed. But one judge, Justice B. Ramaswamy, in 1993, who was charged with corruption when he was served as the Chief Justice of Punjab High Court, and the corruption charges was leveled against him, and he was to be removed. Rajya Sabha passed the resolution, but Lok Sabha abstained itself from voting, and hence the resolution came to an end on the halfway. And Jet Jawad Ramaswamy, then 1992-93, and Soumitra Sen, Justice Soumitra Sen, West Bengal High Court towards 2011, and Justice Dinakaran, he was Sikkim High Court, and he was in 2011, and Deepak Misra, he was in 2018, he was the Chief Justice of India, as all of you know. So although initiation has been made against certain judges for their removal, but it has not been passed or approved completely by the Parliament. Hence, it says or it tells that judges are kept in the stealth frame from the arbitrary and despotic rule or despotic steps taken by the executive and legislature. So this is called your removal of the judges. Okay. Then we will discuss the transfer of judges. Judges can be transferred to one high court from one high court to another for certain reasons, like filling of the quorum or any requirement. the judges, and that will be done by the president in consultation with the CJI. But there is another things that appointment of acting chief justice, if we will discuss appointment of acting chief justice of a high court. Acting chief justice of a high court. Acting chief justice of a high court is also mentioned, or also that is acting chief justice are also appointed by the president in consultation with the CJI of India. And that acting chief justice of high court will be appointed when the permanent or regular chief justice is temporarily absent from his job, or he is unable to perform his duty, or he is removed. Okay, or he is removed by the parliament. So in case of removal, in case of the temporary illness and temporary absence of the chief justice of the high court, the president may appoint any judge of the high court to be appointed as the chief justice of the high court consort. Okay, that is called your things. Then additional judges. Additional judges are appointed by the CJI. Additional judges are appointed by the CJI. Okay, but the acting chief justice you go to the Article 2 to 3. Article 2 to 3. In Article 2 to 3, there is a provision of acting chief justice of India, like your 126. Yes, 126 for the acting chief justice of India. 126 or 127? Article 126 or 127? Okay, that is 126 and it is 123. Then additional judges. Additional judges are appointed by the president, by the CJI, with previous sanction of the president of India. And under Article 2 to 4, it is provided that the president shall appoint any person, duly qualified person. President may appoint a duly qualified person to be additional judge for such period for not exceeding 2 years. Okay. And additional judges are appointed because of to release the backlog or to release the burden when there is a requirement of certain judges for a particular case. Then the president may appoint, or president may appoint. The president will appoint the judges the judges of any duly qualified person to serve as the additional judge of any high court, and in that case the additional judge is entitled to the benefits and the salaries of the judge of the high court for the temporary period. But after the closure of the task or the assignment, they will be not allowed to continue, and so that is that they are not the permanent judge, they are additional judge. And there are also acting judges, acting or temporary judge are appointed under Article 224(2). The acting judges are appointed by the president. Acting judges are appointed by the president with prior approval of the Chief Justice of India, that he may act as an acting judge. There are two circumstances: when there is excess burden on the court, and when the permanent judge is absent, temporarily absent, he can appoint. One person can be appointed to for ad hoc time, for ad hoc purposes, and he will continue until the permanent judge resumes office. That is provided under 224(2). But in no case, not neither in additional judge case nor in acting judge case, the person shall be above 62 years. So no person can be appointed as additional judge or acting judge if he or she is above 62. That is also a point to be noted. Okay. So these are acting Chief Justice, additional judge, and acting judge of the High Court. There is a provision also. And there is also a provision under 224A. That is Article 224A, Article 224A provides for the appointment of retired judges of the same High Court or others to sit as a judge and in a particular case. But in this case, the allowances are determined by the president. They get certain allowances because they're retired judges. So that is also um, okay. So as a judge for a temporary period of time, and that will be appointed. He will be appointed by the CJ with previous sanction of the with previous approval of the with previous approval of the president. Okay, so that is the kind of things. But the retired judges will not get due salary, that they will get certain allowances as decided by the president. Okay, that is 224A. So you see that apart from the permanent judges, there are other provisions for the appointment of other kinds of judges to help the High Court or help the judiciary, state judiciary function smoothly and deliver justice in time. So that is a major lacuna in judicial system, that justice are not delivered at due time. Hence, judiciary is somewhat lagging behind in delivering justice. This is most often commented. So, with a view to relax or with a view to speed up the work, there are certain provisions like the additional judge and the acting judge, even the retired judge, service of the retired judge is also used. Okay, so these are the things about the judges and the things. Now we shall come to the jurisdictions. We have already discussed the independence of the court, so here not necessary to discuss the independence. And I have already told you that judges enjoy functional independence in India. We do not have structural independence, but we have functional independence, judiciary. So we have already discussed the points: mode of appointment, security of tenure, fixed service conditions, salaries charged upon the consolidated fund the non-votable expenditures, the ban on discussion on the conduct of the judges, practice after retirement. So there are several power to punish against his own contempt. There are several things. Okay. Okay, these are the things about the High Court we have discussed. Now we shall discuss the jurisdiction and powers of the High Court. So, High Court, in the sense that it is not a subordinate court under the Supreme Court of India, although we have provided an integrated judicial system, and Supreme Court has retains its big brotherly position in the hierarchy. Yet High Court is not under a directly a subordinate court under the jurisdiction of High Court. It has autonomy, independence, and powers to run on its own to define judiciary and to add to the tradition of the country. So Supreme Court enjoys extraordinary original powers in various matters like federal disputes. High Court has also certain matters like in case of enforcement of fundamental rights and in case of the various things that defining the judiciary procedure in the state. So High Court is just is a superior court or a supreme court in the at the state level. It enjoys extensive and extraordinary jurisdiction powers. It is it has more power, more work to do, more jurisdiction than the Supreme Court, we can say. But the jurisdiction and the powers of the Supreme Court are exactly or are almost same as their counterparts in the pre-independent era. That means the high courts in pre-independent era perform the similar functions as performed by the present high courts. However, one particular thing that was not there, that there are matters related to disputes related to the revenue of the state was not under the domain of the High Court of the pre-independent era, but in the post-independent era, High Courts are assigned with the original jurisdiction to deal with any disputes related to the revenue in the states. So high courts are not that key; they are inferior courts or they are subordinate courts. They are as autonomous and as robust as the Supreme Court in the state matters. So there are certain original jurisdiction, then appellate jurisdiction, rate jurisdiction, then your that is your you can say the writ jurisdiction, then supervisory jurisdiction, control over the subordinate courts, and High Court has also certain advisory power. Then the power of judicial review is also there. Power of judicial review is also there. So there are about 8 jurisdictions of the court of record is also power of judicial 1, 2, 3, 4, 5, 6, 7. So there are the revisory jurisdiction is also there. So now original jurisdiction of the High Court. Original jurisdiction is the jurisdiction in which the High Court has exclusive authority to deal with. And enforcement of fundamental. Let us discuss serially. First, original jurisdiction is the matters of admiralty. Admiralty means the matters arising over the disputes over arising out of the disputes, matters related to or disputes related to that is disputes arising over the territorial water of the country. The territorial water is that extends beyond the coast up to 12 nautical miles, and this is an exclusive zone or exclusive authority of the country concerned. Any dispute arising out of these areas, on these marked areas, any dispute arising on these marked areas will be dealt with by the respective high courts. Respective high courts. Okay, that is called the admiralty. So any matters of admiralty refers to the disputes arising out of the territorial water or territorial sea. So it is not the assignment of the Supreme Court, rather it is the assignment of the high courts to deal with any matter related to cases of admiralty. Then disputes related to MPs, MLAs of the states, election disputes related to MPs and MLAs of the state are also the original jurisdiction of the High Court. Any matter revenue disputes within the state comes under the High Court. And enforcement of fundamental, which is also a jurisdiction of the Supreme Court. It is both a common original jurisdiction because of the primacy of the rights, supremacy of the rights in the Indian Constitution. It has been added to the both. It has been conferred upon the both upon both the courts, like Supreme Court and High Court. So enforcement of fundamental right in case of their violation either by the state or by individual, you can say that it is a common original jurisdiction of both the courts. It is because of the supremacy of the fundamental rights in our democratic political system. Then constitutional cases from subordinate courts also forms the original power of the Supreme Court in effect that from marriage, divorce and company law, marriage, divorce, company law disputes, they are come under the original power of the High Court. So you have seen that High Court has a lots of original jurisdiction under its jurisdiction, but this jurisdiction is confined within the territorial limit of the state or the state's concerned. It doesn't have extraterritorial jurisdictions. It doesn't have extraterritorial jurisdiction. Then in case of appellate jurisdiction, obviously because High Court is the highest court of appeal in the state, it hears appeals against the judgment of the high courts and other judicial bodies except military tribunals. That is also the point to be remembered against the judgment of subordinate courts, other judicial bodies like tribunals. Other except martial courts or military courts or tribunals. On any both civil and criminal matter, it has the authority to hear appeal against the judgment of other courts. So it is the highest court of appeal in the state. So then read jurisdiction of the High Court. Read jurisdiction is a unique jurisdiction read by special orders of the court issued for the enforcement of fundamental rights. High Court and Supreme Court are both are empowered to issue writs on the enforcement of fundamental rights. So under Article 226, High Court is empowered to issue writs when there is a case of violation of fundamental rights. However, High Court can also issue writs for other purposes. It can issue. So High Court's 226 is wider than Article 32. Under 226, High Courts can do all things, but under Article 32, the Supreme Court can issue writs only for the enforcement of fundamental, not for other purposes. Okay, hence it is called the read jurisdiction of the High Court. The read jurisdiction of High Court is wider than that of the Supreme Court. Supreme Court can entertain writs only if it is related to fundamental rights. But High Court can issue writs not only if the matter is not only related to fundamental rights but also other matters. So that is also a biggest difference. Hence Article 32 or Article 226 is wider than that of the 32. However, 32 is a fundamental right, but 226 is not a fundamental right. So right to move to the Supreme Court for enforcement of fundamental right is a fundamental right itself. Whereas under 226, it is not. So High Court may deny to entertain, but Supreme Court cannot deny to entertain. And this writ power is conferred to the courts by the Parliament. So writ jurisdiction is the authority of Parliament to share. And in Chandrakumar versus Union of India case 1997, the Supreme Court held that writ jurisdiction constitutes the basic structure of the Constitution, hence it cannot be taken away, abridged or diluted. So in a democratic country or in a democratic country where justice is the most sought after thing, and people, the arrangement of our justice is quite enlarging, there we require writ jurisdiction for the enforcement. That is 226. Then supervisory and control power jurisdictions. Supervisory and controlling power of the supervisory power. High Courts have both judicial and administrative superintendents. It can describe the format, the procedure for the judges. It can determine the modus operandi of the various courts in the court. So it has complete supervisory control over the subordinate courts and others judicial bodies. Hence, the subordinate courts are so called. It enjoys both judicial and administrative superintendents. And such superintendence is revisionary in jurisdiction, means it can change from time to time by the High Court. So High Court is has the supervising authority over the subordinate courts. Then control over subordinate courts, apart from the supervisory control, supervisory jurisdiction. There is also some controlling jurisdiction over the high courts of the high courts. The High Court is consulted by the governor of the state in the appointment, posting, and transfer of the district judges, matters and appointments of the district judges. That is right. In the matters of state judicial members of state judicial services, governor consults the high courts and the state public service commission, and it can withdraw any cases pending in the subordinate courts which requires constitutional interpretations. It is consulted but the laws of the High Court is binding on all subordinate courts in the state. That is called controlling authority of the High Courts. That is called your control over the subordinate courts. 233 mentions about the supervisory and control authority. Then the High Court as a court of record, like the Supreme Court, High Court is also a court of record under Article 215. We have already explained the term court of record, that power to punish for its own contempt, and the judgments of the court are preserved for eternity for reference. So this court is a unique court of record, is a unique power that the that it has the power to punish for its own contempt, and its judgments are of permanent value. So these are the jurisdiction of the High Court, and there is also a jurisdiction called power of judicial review, a unique weapon in the hand of the judiciary to review any legislative acts or executive actions, bylaws, to establish the constitutionality of theirs. High Court and Supreme Court conducts judiciary to ascertain that whether the act or order in question violates the Constitution or not, transgresses the fundamental rights or not, or is prepared by competent authority or not. So, on three grounds, you can see the judicial review can be assumed. That is whether it violative of the Constitution. Number two, violative of the fundamental rights. Number three, whether prepared by a competent authority or not. So it can review an act of the state legislature on the action of the state executive or ensure, and it can also review the parliamentary acts. That is also a point to be kept in mind. That High Court has the authority to review parliamentary acts even, and it through judicial review it establishes these things, and it is inspired by the American High Court. And obviously, democracy needs a responsible judiciary, accountable judiciary, and the accountability of judiciary is ascertained or is realized through this procedure of this power of judicial review. Okay, so we have discussed the high courts and their jurisdiction, their powers, their functions. Remember that high court is a supreme court at the state level, and it has several various things. And you can see that I have given you the articles we have already discussed, and there are 25 high courts and total judge sanction 1079, permanent 771, additional 308. As of October 2022, 404 seats are lying vacant. You can also get updated in this regard. Okay. And remember the vacancy, we have skipped a point, that the vacancy in the judge Number one, death. Number three, resignation. Number three, removal. Acquisition of. Okay, guys. So we have completed high courts, and as you know, high courts are. We have already discussed how effective they are in the state level, and what are the jurisdiction, and also the independence of the court, transfer of the court. We have also discussed a lot about other judges, oath, salaries, retirement. I told you the 15th Amendment increased the retirement of the judges, and common high courts. Okay, so in the next class, we shall be just have a discussion on subordinate courts. And subordinate courts, in case of subordinate courts, we'll find that there are various things which are lawn. What how many types of subordinate courts are there, and how do they function, how they are kept under the jurisdiction of the high court, how they are governed, controlled, superintendent by the high courts. Okay, so kindly follow us. Next week we shall be completing the judiciary. We'll also discuss judicial review, judicial activism, judicial restraint, what are the implications, and public interest litigation in that regard also. We shall discuss broadly about this unique procedure of the judiciary in India, power of judicial review, judicial activism, what is the necessity of judicial activism or judicial adventurism, whether it is called a judicial overreachness. Is judiciary interfering? Is judiciary imposing or presenting itself as a popular institution or people's institution and directly involved with the people? Is it possible for a judiciary to come in interaction with the common people? And what will the legislators do? What will the executive will do? So that is the question mark. Hence, there is no need. Okay. And as I told you, next class we shall be starting with the subordinate courts. Then, if time permits, we shall continue with the state executive parts. Okay. So these are the things of the past, and next class we shall discuss the subordinate courts. Okay. Thank you very much to all of you. Keep preparing yourself. Keep confident, and go ahead. Thank you very much to all of you again.